Hey, Janelle, do you still need more time?
You could do it now. You could do it.
Can I say something?
You are here for an initial appearance after detention. The rules of criminal procedure require that you be brought before a judicial officer within 24 hours of your arrest. The purpose of the initial appearance is to have a judge list the charges against you, inform you of certain rights that you have, and to determine the conditions of your release. You should have already received a copy of these charges. The judge will review your paperwork to determine if there was probable cause to arrest you. If the judge finds probable cause, he or she will then determine if you qualify for bond and what the monetary and non-monetary conditions of your bond should be. If the judge does not have enough information to make a probable cause determination for your arrest, the state may be given additional time to amend the paperwork. You should also be aware of the following rights afforded to you by the Constitution. You are not required to say anything at this proceeding. Anything you say can be used against you. You have the right to communicate with counsel, family, or friends, and if necessary, you will be provided a reasonable means to do so. You have the right to counsel. If you have not already retained counsel and cannot afford counsel, the judge will appoint you a public defender. For the purposes of today's initial appearance proceedings, you may be able to briefly speak with a public defender regardless of whether the public defender is appointed for you. In order to have an attorney appointed by the court to represent you, you must be financially eligible, as determined by the court based on financial information you provide. Therefore, if you have not already done so, please complete, to the best of your knowledge, the financial affidavits provided by the correction officers. An application fee for the services of appointed counsel will be assessed. If you do not speak English or Spanish, please let a corrections officer know. When the judge is ready, she or he will begin calling your case by name. Please listen carefully for your name. When called, please approach the microphone as directed by the corrections officers. Thank you.
Usted se encuentra aquí para una audiencia o vista preliminaria, después de haber sido arrestado. Las leyes y estatutos criminales del estado de la Florida requieren que se celebre una vista preliminaria ante un oficial judicial dentro de un plazo de 24 horas después de su arresto. El propósito de esta vista preliminaria es para que el juez pronuncie los cargos contra usted, para que se le comunique a usted sus derechos procesales y para determinar las condiciones de su libertad o fianza. Ya usted debería haber recibido una copia de estas alegaciones o acusaciones por escrito. Ahora, el juez revisará la documentación en su caso para determinar si existe motivo fundado o causa probable para su arresto y detención. Si el juez determina que existe causa probable o motivo fundado, entonces decidirá si usted califica para que se le otorgue una fianza, tanto como cuáles serían las condiciones monetarias o no monetarias de dicha fianza. Si el juez no posee suficiente información para determinar si existe causa probable o motivo fundado para justificar el arresto, se le concederá a la Fiscalía tiempo adicional para modificar la documentación. También se les avisa que posee los siguientes derechos que se les otorgan por la Constitución. A usted no se le puede obligar a decir nada durante esta vista. Cualquier cosa que diga podrá ser utilizada en su contra como evidencia. Usted tiene el derecho de comunicarse con un abogado, pariente o amigo, y si es necesario, que se les proporcione los medios razonables y disponibles para hacerlo. Usted tiene el derecho a un abogado. Si todavía no ha encontrado o contratado un abogado y no tiene los recursos para hacerlos, entonces el juez le nombrará un defensor público. Para el propósito de la audiencia preliminaria de hoy, se le permitirá hablar brevemente con un abogado de la Oficina del Defensor Público, aun cuando no se le haya nombrado para representarle en todo el caso. Para poder recibir la designación de un abogado, primero debe calificar económicamente según lo determine el juez. Esto será basado en la información financiera que usted proporcione aquí. Por lo tanto, si no lo ha hecho todavía, de la mejor manera posible, por favor, llene el formulario de insolvencia económica que se le ha proporcionado por el oficial de correcciones. Se le impondrá un recargo o costo por los servicios del defensor público. Si usted no habla inglés, por favor, hágale saber al oficial de correcciones. Cuando esté listo, el juez comenzará el proceso llamando a cada una persona y caso por su nombre. Por favor, esté pendiente para pasar adelante cuando escuche su nombre y cuando escuche su nombre, haga el favor de acercarse al micrófono, tal como le indique el oficial de correcciones. Muchas gracias por su atención.
All right, good afternoon, everyone. I'm Judge Epperson. We're here for initial appearances. I believe that you've already seen the video explaining the purpose of this brief hearing, so we're going to get started. When I call your name, come directly to the podium and we will hold your initial appearance. I want to begin by having personnel from the State Attorney's Office and Public Defender's Office announce their presence from the state.
Kelly Hicks on behalf of the state.
Last name again?
It's HICP.
All right, thank you. And from the Public Defender's Office?
Janelle Clark.
Okay, and then we have someone there from PTR.
Sanjay Henderson, Your Honor.
Thank you. All right, I'm going to go ahead and begin with our interpreter matters first. Luis Acosta can come forward. Luis Acosta.
Approach.
PD's office.
Try again.
Good afternoon, Your Honor. This is Laura Arroyo, State Certified Interpreter and previously sworn.
All right, Ms. Arroyo, good afternoon. We're doing initial appearance, so the translation will need to be consecutive.
Yes, Your Honor.
All right, Mr. Acosta, good afternoon. You've been arrested on a warrant out of Seminole County.
Buenas tardes, señora Costa. A usted la han arrestado por una orden de arresto que proviene del condado de Seminole.
The arrest was for failing to appear for an arraignment on a driving while license suspended case.
Yes, sir.
El arresto fue por su falta de comparecencia el día de la vista en coatoria con respecto a la acusación de conducir con licencia suspendida.
The court did give you a bond in the amount of $500. That is your bond amount, and Seminole County will be notified of your availability for pickup.
El juzgado le concedió a usted fianza de $500 con respecto a esta acusación y se le notificará a Seminole para que vengan a recogerle.
Case number was 22C1777. All right, Mario Cato, come forward. Mario Cato. All right, sir, good afternoon. You've been arrested on a warrant for failing to register within the time required by law as a sexual offender.
Bien, señora, usted lo detuvieron por su falta de registrarse tal como requiere la ley de la Florida siendo depredador sexual.
You need to submit an application if you wish to be considered for the Public Defender's Office.
Si usted desea que se considere designarle defensor público, tiene que presentar usted la solicitud.
Bond is $5,000 and you must register within 24 hours of your release as required by law.
La fianza será $5,000 y es obligatorio que usted se inscriba tan pronto sea puesto en libertad dentro de un plazo de 24 horas, tal como requiere la ley.
25 CF 1110.
Next court date on demand.
La próxima vista será por señalamiento judicial.
The next case, I was informed that we may have private counsel either present or on the way. Francis Crespo, I don't see private counsel in the courtroom. Ms. Clark, do you see private counsel there?
No, Your Honor.
Okay,
I did speak to her and she did assume her counsel was coming though.
Okay. I will go ahead and call Ms. Crespo's case when I'm finished with the others to allow more time for her attorney to arrive.
Thank you, Your Honor.
We'll go next to Fernando Morales Arriaga, 25 CT 1466.
Fernando Morales. Approach.
All right, good afternoon, sir. The Public Defender's Office is appointed to represent you. This is Ms. Clark, standing to your right.
Buenas tardes, señor. Se le ha designado defensor público para asistirle jurídicamente. La licenciada Clark es la que está a su derecha.
Ms. Henderson, the cover sheet from pretrial release has the words immigration status and a check mark next to non-qualification for PTR.
Señora, parece ser que en la hoja del programa de libertad provisional consta marcado estatus migratorio y que no cualifica para el programa de libertad provisional.
Does We probably at least have any factual basis to believe that the arrestee is an unauthorized alien?
El personal de la libertad vigilada, la libertad provisional tiene algún fundamento fáctico para poder demostrar que el inculpado arrestado entró clandestinamente.
Your Honor, immigration wasn't able to give us an answer on whether or not he was illegal or legal to be in the country.
Su señoría Migración no nos pudo dar respuesta con respecto a si él se encuentra en el país de manera irregular o regular.
That's an odd inability for that particular governmental agency.
Extraño que esa entidad gubernamental no pueda decirlo.
Court finds probable cause for driving under the influence, set bond in the amount of $2,000. Should you make bond, sir, you're not to possess or consume any alcoholic beverages or go to any bars.
Bien, se determina que existe indicios de criminalidad para sustentar la acusación de conducir bajo los efectos. Se fija fianza en $2,000. Señor, si usted logra salir de la cárcel, estará prohibido el consumo de alcohol o frecuentar ningún bar.
Next
Gracias.
court date, April 24th, 2025, 8:30 a.m., courtroom 4E. If out on bond, April 29th, 2025, 8:30 a.m., courtroom 4E.
La próxima vista será el 24 de abril a las 8:30 en la sala 4B. Si se encuentra libre bajo fianza, entonces será el 29 de abril a las 8:30 en la sala 4E.
Leticia Valdez, 25, CC 1107, 07 or 67, 1167. All right, Ms. Valdez, the public defender is appointed to represent you. This is Ms. Clark standing to your right.
Muy bien, señora Valdez. Se le designa defensor público para asistirle a usted jurídicamente. La licenciada Clark es la que se encuentra a su derecha.
There are three listed offenses. The court finds probable cause for two of the three.
Tenemos enumerados 3 ilícitos y se determina que existen indicios racionales de criminalidad con respecto a 2 de esos 3.
Probable cause for battery as listed in count 1. Probable cause for child abuse as listed in count 2.
Entonces se determina que existen indicios de criminalidad con respecto a la primera acusación de agresión física y la segunda de maltrato de menor.
Will be 1,000 for each of the counts. With respect to count 3, the court finds no probable cause, and Ms. Valdez will be released on her own recognizance as to count 3 only.
Se impone fianza de $1,000 con respecto a cada una de esas acusaciones y sobre la tercera acusación se determina que no existen indicios racionales de criminalidad y se le concede caución juratoria a la señora Valdez solo con respecto a esa tercera acusación.
Valdez, until further order of the court, you're not to return to 1080 Jack Calhoun Drive in Kissimmee.
Hasta que exista disposición judicial contraria, señora Valdez, usted estará prohibida regresar a la 1080 Jackson Court. I'm sorry, Your Honor, could you repeat the name of the street?
Jack Calhoun Drive in Kissimmee.
No puede regresar a la 1080 Jack Calhoun Drive en Kissimmee.
I will grant an assist order for a one-time return with the assistance of the sheriff's office for acquiring personal belongings such as clothing, toiletries, or items for work.
Bien, y se le concede, una vez escoltada por agente policial, poder regresar a ese lugar para recoger sus pertenencias, los cuales incluyen vestimenta, ropa, artículos de trabajo.
Also, until further order of the court, you're to have no contact with Leonardo Valdez and no contact with Israel Valdez. I realize those are your children, but until further order of the court, no contact.
Y hasta disposición judicial contraria, usted estará prohibida tener ningún tipo de trato o comunicación con Leonardo Valdez o con Israel Valdez. Reconozco que son sus hijos, pero hasta que se indique lo contrario, usted estará prohibido contacto con ellos.
Clark, were you wanting to say something?
Yes, Your Honor.
Licenciada Clark, ¿usted quería decir algo?
Yes, so in the affidavit, it looks as if the father took the custody of the 2 children and took them with him. So is it possible we could say maintain a separate residence in case they do decide to stay with their father?
Sí, su señoría, en el affidavit indica que el padre tomó la guardia de custodia de los menores y están con él. Por lo tanto, pedimos si posiblemente se pueda hacer constar que está prohibida la convivencia con los menores, ya que los niños están con el padre.
While your request is not unreasonable, I'm going to keep it as it is for now. Do we know which trial division this is in front of?
Aunque su solicitud no es razonable, lo mantendré tal cual como indicado por ahora.
Is that Wilson, Parsons, Wilson? Okay, so that'll be in front of Judge Tanya Wilson, so you could perhaps get an expedited motion in front of her for that purpose if it's appropriate.
Este caso se celebrará ante la juez Wilson. Si usted considera que corresponde, puede solicitar una audiencia expedita ante ella.
Thank you.
Thank you, Your Honor.
Gracias. La próxima vista será por señalamiento judicial.
Okay, yeah, by chance, has the private attorney for Ms. Crespo shown up in the courtroom yet?
No, Your Honor, I do have one other Spanish that may not have been on the list. It is Martinez Figueroa.
Okay, yes. Okay, forward. Jose Martinez Figueroa. All right, Mr. Martinez Figueroa, you've been arrested on a warrant out of Orange County for failing to appear on a felony drug case.
Bien, señor Figueroa, usted fue detenido por orden de arresto que proviene del condado de Orange debido a su falta de comparecencia en un caso que tiene usted de droga como delito.
23 CF 13511. The trial court set no bond due to the failure to appear. Orange County will be notified of your availability for pickup.
Bien, el juez del condado de Orange impuso prisión preventiva por su falta de comparecencia. Se le notificará al juzgado de Orange que usted está disponible para que lo vengan a recoger.
All right, any other interpreter matters other than Crespo?
Yes, Your Honor, I have one more. Mr. Valera Sanchez. That should be the last one, Your Honor. I apologize.
That's all right. Okay, we have two cases. Case 25 CF 1168. Just a moment. Okay, the court finds probable cause for 3 counts of aggravated assault with a firearm.
Bien, en el caso 25 CF 11868 se determina que existe indicios racionales de criminalidad con respecto a 3 acusaciones de intimidación calificada con arma de fuego.
History.
Licenciada Henderson, antecedentes.
Your Honor, the defendant has no prior criminal history.
All right.
Su señoría, el inculpado carece de antecedentes.
We're setting bond at $5,000 on each count for an aggregate of $15,000. Should you make bond, you're to have no contact with the alleged victims, Alondra Lara, Gianni Lara, and Minerva del Carmen Casanova.
Bien, se impone fianza de $5,000 con respecto a cada acusación, un monto total de $15,000. Y como disposición judicial, si usted logra salir bajo fianza, estará prohibido tener ningún tipo de trato o contacto con las presuntas víctimas Alondra Lara, Gianni Lara, Minerva del Carmen Casanova.
You must not possess any weapons or firearms.
Prohibida la tenencia de arma de fuego o arma alguna.
And until further order of the court, you're not to be in actual physical control of a motor vehicle.
Y hasta disposición judicial contraria, entienda que está prohibido tener control directo y físico de un vehículo motor.
Turning to case 25MM881, court finds probable cause for violation of a domestic violence injunction.
Y con respecto al caso 25MM881, se determina que existe indicios de criminalidad con respecto a la acusación de incumplimiento de orden de alejamiento por violencia doméstica.
nature of the alleged violation. I'm setting bond at $5,000. Also, you must abide by all terms of any active injunctions and not possess any weapons or firearms.
Bien, teniendo en cuenta la naturaleza de la acusación, se impone fianza de $5,000 y además cumplirá usted con los términos de cualquier orden de alejamiento activo y prohibido la tenencia de ningún tipo de arma de fuego o arma alguna.
Latter case, the violation of injunction is 25 mm 881.
Ese último caso de incumplimiento de la orden de alejamiento es el número 25 mm 881.
Thank you.
On demand, PD was approved. Okay.
Se aprobó defensor público para ambas acusaciones y la próxima vista será por señalamiento judicial.
All right, and Ms. Clark is a friend of the court. If that attorney arrives, just let me know. I'll probably call that last anyway, though. And I'm going to go ahead and excuse our interpreter, Ms. Arroyo. Thank you.
You're welcome, Your Honor. The interpreter will disconnect.
All right, turning now to all non-interpreter matters. Farrell Beasley. Farrell Beasley, come forward. All right, Mr. Beasley, good afternoon. You've been arrested on an alleged violation of probation from Polk County. The case number is 22 CF 6366. The Polk County trial court set bond at $0. It will remain $0, and Polk County will be notified of your availability for pickup. Thank you. Deanna Kent.
She's coming.
She's in the cage, Your Honor. 1 second.
All right, Ms. Kent, good afternoon. You've been arrested on a Polk County warrant, 25 MM 1775, failing to appear for an arraignment, stalking allegation. The court in Polk County indicated that the court would be satisfied releasing you on your own recognizance if there was a valid address for you so that you could receive all of your future court date notices. Are you living in a stable residence?
Yes.
All right. As a friend of the court, Ms. Clark, can you briefly talk with her about whether or not that address has been provided already?
Yes, Your Honor, 1 second.
Wasn't on the ballot.
Your Honor, she says no one has asked her for the address until now.
Okay. Why don't you go ahead and state it right now?
780 West Davidson Street, Bartow, Florida.
$780?
Yes.
And say the street again.
Davidson.
West Davidson Street? West Davidson Street.
Spell Davidson.
DAVIDSON.
And what's the zip code?
33803. Or 30, I'm sorry, 33830.
And is that in Lakeland?
Bartow.
Bartow? And that's where you live,
Yes.
correct?
Yes. I just got.
And that's where you will receive mail.
Yes.
And if you're released on your own recognizance, you're going to go to your next court date.
Yes.
Okay, well, that's a pretty gracious judge in Polk County to give you an ROR on a failure to appear. Hopefully you'll take advantage of that and show up for your court hearing. The defendant will be released on her own recognizance. I don't have a court date from Polk County right now. So that's it.
I'll contact the court, sir.
All right, that'd be a good idea. Thank you. Joseph McKenzie. All right, Mr. McKenzie, good afternoon. Been arrested on a violation of probation warrant out of Orange County. Underlying charge was a battery, case number 18 CF 10500. The issuing court set bond at $0. It will remain at $0. However, Orange County will be made be notified of your availability for pickup. Thank you. Yannick DePina.
Approaching.
PD approved.
All right, good afternoon. Mr. DePina, you've been arrested on a warrant for failing to appear for arraignment on a burglary and theft allegation in case 25 CF 500. Judge Karsten set your bond at 0. It will remain at 0 at this time. Your next court date?
2025, 8:30 a.m.
I'm sorry, Your Honor, there was some noise in the background. Could she repeat?
Sure.
Next court date, May 7th, 2025, 8:30 a.m.
Thank you.
Monica Emanuel. All right. Good afternoon, Ms. Emanuel. You've been arrested on an alleged violation of probation. Underlying charge was a delivery of cocaine. Judge Beamer set your bond at 0 on the violation of probation. It'll remain 0 at this time. Court case 22 CF 2933. Madam Clerk, next court date.
Next court date, May 28th, 2025, 5 a.m. courtroom 5A.
Thank you. Jonathan Myers.
Approaching.
Approved, both dates.
All right, there's 2 separate matters, so I'll address them individually. First of all, case 25 CF 287. 25 CF 287. Sir, you've been arrested on a battery by strangulation, count 1, and the domestic battery on count 2. I'm setting your bond at $5,000 on count 1. State is standing. Ms. Hicks, you should be heard.
They filed a motion for pretrial detention.
Okay. All right, Ms. Clark, the state has filed a motion for pretrial detention in these matters. And so we'll, Madam Clerk.
Date, April 17th, 2025, 8:15 a.m. courtroom 5.
All right, so the defendant will remain, or the arrestee will remain on no bond on each of these matters, but set for an expedite.
Judge, just so the record's only filed the motion for pretrial detention in the felony case, not the misdemeanor.
Yeah, so he's going to be brought back to the podium there so that I can address the misdemeanor case. He had 2 cases. Unless he's continuing to be disruptive. That would be Mr. Jonathan Myers. Jonathan Myers.
One moment, Your Honor.
Matter.
They're bringing him back, Your Honor.
Yeah, you might be interested in addressing the court. You wish. If he's being in any way disruptive, I'll consider that a waiver.
Yes, Your Honor. Could we waive his appearance?
Yeah, in case 24MM2530, I'll set his bond at $1,000. He's to have no contact with Veronica Hancock, not to possess any weapons or firearms. I was going to ask him about whether he needed an assist, but since he's not there, that question won't be posed. All right.
Thank you, Your Honor.
Going next to Christopher Brown. Christopher Brown,
Approaching.
you here on the Crespo matter? Ma'am, are you here on the Crespo matter? Okay, yeah, I'm going to call that up at the end. Okay, it won't be long.
I'm sorry. Thank you. Christopher.
All right, Mr. Brown, good afternoon. I've reviewed the police report. I do find probable cause for trespassing. I'm setting your bond at $500. You're not to return to the St. Cloud Veterans Memorial Library at 810 13th Street in St. Cloud. Public defender's been appointed. And your next court date, you'll receive. All right? Thank you. Christopher Everett. Is there a T in there?
Good morning, Your Honor.
All right, good morning, sir. Court does find probable cause for driving while license revoked. The state attorney's, assistant state attorney is standing. Ms. Hicks?
I filed an information in this case earlier. I charged him with misdemeanor M1 bills. So the court could set the bond on the file.
Okay. I'll set the bond on the filed charge, but the bond will be $2,500. And Mr. Everett, you're not to be in actual physical control of a motor vehicle until further order of the court. All right, sir?
Oh, I didn't hear the bond, sir.
$2,500 bond. Yes,
All
sir.
right,
No driving.
and they drop it.
Yeah.
Right, Catherine Gaviria. All right. All right, the court finds no probable cause for the listed charges. The arrestee will be released on her own recognizance. In the narrative of the officer, it appears that the arrestee wasn't being cooperative. However, there's no description of how she actually resisted handcuffs in the narrative. It says that in a conclusory fashion when he's justifying the charge. And then with respect to the battery, in the first paragraph of the narrative where he's really providing the facts, it is not clear at all that one of the beer cans actually hit the alleged victim. So based on what I have before me, no PC. Ms. Gaviria, this does not mean that the state is not going to prosecute. That's their independent decision. I just don't have sufficient cause to keep you in custody, so you'll be released on your own recognizance. Thank you.
Thank you.
Shahzaib Khan. All right, sir. Good afternoon. There's two listed charges. The court finds probable cause for count 2, possession of drug paraphernalia. With respect to count 1, it's residue on a straw. Find no PC on count 1. However, your bond on count 2 will be $2,500. You're not to possess, ingest, or consume any illegal substances or any controlled substances without a prescription. I set it at $2,500 because of information the court was provided about excessive prior failures to appear. Ms. Henderson, can you verify that?
Yes, Your Honor, that is correct.
Okay, so it'll be $2,500 and your next court date will be announced. You'll receive it. Thank you.
What about count 1?
They are. I can explain it later. Just have a seat, okay? I'll explain it to you.
ROR on count 1. Right, Camila Lopez Alvarez. All right, Ms. Lopez, public defender is appointed to represent you on probable cause for the offense of battery, setting your bond at $500. Should you make bond, you're to have no contact with Krishan Hoylett until further order of the court. That's no contact. Not to possess any weapons or firearms, and until further order of the court, you're not to return to 484 Acacia Tree Way. All right, your next court date, you'll receive. Thank you. Amanda Mosley. Okay, defender is appointed. Ms. Hicks is standing from the state attorney's office. Ms. Hicks.
Information has been filed charging her with M2 drills.
All right, Ms. Mosley, the court does find probable cause for driving while license suspended with knowledge. I'll set your bond at $500. And you're not to be in actual physical control of a motor vehicle unless you have a valid Florida driver's license. Your next court date, you'll receive. Thank you. Andrew Oldfield. All right, sir. Public defender is appointed to represent you. This is 25 MM 871. Court finds probable cause for the listed offense of battery. I'm setting bond in the amount of $1,000. Should you make bond, you're to have no contact with Diane Lisa Evans. You're not to possess any weapons or firearms. Unfortunately, as you know, you're on probation in case 24 MM 2878. Based upon probable cause of a new law violation, as well as the fact that one of your conditions of probation was to have no hostile contact with Ms. Diane Lisa Evans, I do find an on-view violation of probation. And so there'll be a zero bond on 24 MM 2878, and the state will have 72 hours to consider filing an affidavit of violation. Next court date, you'll receive. Thank you. Cesar Sarah Diaz. All right, sir. Good afternoon. Public defender is appointed. The court does find probable cause for aggravated assault I'm setting your bond at $10,000. Should you make bond, you're to have no contact with Norberto Sierra Diaz. I realize he's your brother, but no contact. You're not to return to 1115 Cobblestone Circle in Kissimmee. You must not possess any weapons or firearms, and you must not possess or consume any alcoholic beverages or go to any bars. Your next court date, you'll receive. Thank you. Millennia Simmons.
Sir.
All right, public defenders appointed to represent you. Is it Ms. Simmons or Simons?
Simmons.
Simmons.
Yes, sir.
All right, the court does find probable cause for battery, setting your bond at $500. Until further order of the court, no contact with Daniel Rakowski. You're not to possess any weapons or firearms. Next court date, you'll receive. David Stone, 25 MM 878.
Your Honor, I do have a PC argument for Mr. Stone.
All right.
Yes, Your Honor. So within the four corners of the affidavit, it looks like there may be an HR policy violation, but according to the law, it looks as if he was defending himself. It doesn't look like he used excessive force. It looks like the student attacked him first repeatedly, and like I said, he used the force needed to stop him from being attacked.
All right, state your response, if any.
Stand your ground as a motion to have to file and be heard.
Okay. The issue before the court is not whether there's probable cause to believe that the arrestee, Mr. Stone, could have handled the situation better, but whether there's probable cause that he committed the criminal act of battery. And based on the totality of circumstances, I concur with Ms. Clark's position. Mr. Stone will be released on his own recognizance.
Thank you, Your Honor.
Thank you. Zane Syed. All right, Mr. Syed, good afternoon. Public defender is appointed to represent you. The court finds probable cause for possession of fentanyl and possession of drug paraphernalia. Your bond. Ms. Henderson, any other information on the notation immigration status?
One moment, Your Honor, please. No, Your Honor, I don't have any other information.
Six.
Residue case, like the other case, that guy, I'd like you to treat this guy like you treated the last guy.
Say the last thing you said about you'd like to.
I think you should treat this gentleman the way you treated the other guy with the residue.
Oh, were you assuming disproportionate treatment?
No, but you said you found PC on both, and the last time you said you didn't find PC on the residue.
Right. But this one was a little bit different. Let me just tell you what, hang on a minute.
I agree.
Yeah, there is a difference in this case, not in the issue of the residue, but in the totality of circumstances, which would be the predicate paragraph. All right. So in count one, I'm setting your bond at $2,500 on the possession of fentanyl, and count two on possession of drug paraphernalia, $500. Should you make bond, you're not to possess, ingest, or consume any illegal substances or any controlled substances without a prescription. And your next court date, you'll receive. All right. Thank you. All right, Carl Martin. All right, so this case was already had an initial appearance. Judge Kirsten. Came before Judge Karsten, no bonded, and that was predicated, apparently that was predicated upon the state's representation that it intended to file pretrial detention. Any updates on that, Ms. Hicks?
Mm-hmm.
Well, they've not filed pretrial detention, correct? Okay, there's no secrets here. Madam Clerk just said she was made aware that the state was not going forward on pretrial detention, and what's the basis of that awareness? By the court clerk in Judge Wilson's division? Okay. And in full transparency, the court received an email that this was coming back to initial appearances because the state was not pursuing pretrial detention. It still seems odd that it comes back to IA. It should have just been set for a bond hearing in the court's humble opinion. There's already been an initial appearance. And that notwithstanding, the defendant is entitled to consideration of bond since this is not a capital crime or a punishable by life. Having reviewed the arrest warrant, does contain very serious allegations of aggravated assault with a firearm. Ms. Henderson, history?
One moment, Your Honor. Your Honor, defendant has no prior history.
Okay. All right, the court will set bond at $7,500. Should you make bond, sir, you're to have no contact whatsoever with no contact whatsoever with Israel Wynn, no contact whatsoever with Quinteray Lanier Simpson, must not possess any weapons or firearms, and your next court date, you'll receive. Thank you. Mike was off there, but.
Sorry, he said thank you. That was all.
Oh, okay. You're welcome. Okay, and then finally we have two more actually. We have Rolfie Santos was a reset on a DUI. It was a wheel witness issue, at least from the court's perspective. Ms. Hicks, any updates?
Emailed the law enforcement officer, got no response.
All right, Mr. Santos, you'll be released on your own recognizance today. Now, this does not in any way suggest that the state is not going to prosecute the case. It just means I don't have sufficient facts before me at the moment to keep you in custody, so you're released. Make sure that you have your most current address with the jail there, and if there's any changes in address, update so you don't miss any court dates. All right, thank you.
Thank you, Your Honor.
April 24th, 2025, 8:30 a.m., courtroom 4E. Out on bond, 25th, 2025, 8:30 a.m., courtroom 4E.
April 25th at 8:30 a.m.
Yes, ma'am.
Thank you. At your next court date. Make sure.
Okay, and then Francis Crespo, hopefully she's still there.
Yes.
Okay. All right, Counselor, you want to announce your appearance?
Yes, Your Honor. Huda Salah on behalf of the defense.
Your last name again?
Salah, S-A-L-E-H.
All right, Ms. Crespo is before the court on an arrest for a violation of probation in case 24MM329. The violation of probation warrant initially had a zero bond. It came to my attention that Judge John Savage may have already set a $2,000 bond in the case, however. Is that your understanding?
Yes, we had a hearing on this exact issue yesterday morning, actually, and she granted a bond on the BOP warrant.
Okay, so let that reflect $2,000 bond on case 24MM329. Apparently, it's already been established by Judge John Savage, and it will remain at $2,000. Case number 24MM329, underlying charge was a theft, alleged violation for alleged criminal traffic matters and failure to pay cost of supervision. Counsel, anything else you wanted to say?
Just briefly, the only reason I'm here actually is because I was told for some reason the jail was not releasing her despite there being a bond on the warrant. So maybe it just wasn't visible before, but I wanted to see if there's any molds that we need to be aware of. I don't think there is.
Okay, I don't know if anyone there from corrections can give that Johnny on the spot information, but the bond on this case is $2,000, so she should be able to post bond on this case unless there's some other hold. She should be released.
I could help, Your Honor. Normally, if the defendant is arrested and then there's a warrant, they hold them until they come before the judge. If there wasn't an arrest, then normally they're allowed to bond out. At least those are the only rules that I know of, Your Honor.
Okay. Well, obviously she has other criminal charges. Because, I say that just because I'm looking at the affidavit of violation. The reason it was a violation was because of the DUI and Willis and other things, but presumably she has bond on those cases.
Yes.
So, all right. Anyway, your attorney is here, Ms. Crespo, on your behalf. Can you see her on the camera?
No, but thank you, Your Honor, for waiting for the attorney.
Okay. All right. Have a good day. Thank you.
Thank you.
Thank you. April 24th, 2025, 8:30 a.m., courtroom 4E. If out on bond, April 30th, 8:30 a.m., courtroom 4B.
I just remembered that she was on the list for the interpreters, but she seemed to understand. Are you okay?
She did.
Yeah.
Yeah.
Okay, great. All right. Thank you, Ms. Clark.
Thank you, guys. Have a good day.
I'm sorry, regarding the court date, we got a court date of I think May 28th for a BOP status yesterday. So there was a reason it was set out for May, but I heard you just say April.
What I see on the doc. Yep.
Okay, come back on this side.
What happened in real time in court maybe didn't get in the system yet.
That's what I'm thinking.
Guessing.
Okay.
Yeah.
Your Honor, I'm sorry, we do have, one case here. It is Camelia Lopez Alvarez. She was ordered a no return, and we were wondering
Acacia Way.
if she have a one-time return with law enforcement.
Okay, was that 414 or 484 Acacia Way, I believe?
Yes, sir.
Yes.
One moment. Thank you. Have a good day.
And did you have the correct address for the court? Did you want to give the court your most current address? You want to tell it to the clerk now? Your Honor, she also wanted to give the clerk her most current address. I don't know if that's something we can do here.
Sure.
Okay, could you say it on the record?
Yes.
Do you want me to read this here?
Yes, down.
The 1000 Douglas?
Yes.
It's 1000 Douglas Avenue.
Actually, that's on the police report, I believe.
Oh, yes, it's actually the one on the avenue. Yes, Alamana Springs 32817.
Yes, sir.
Okay, yeah, that's on there.
Okay, so the court will grant a one-time return with the assistance of the sheriff's office to 484 Acacia Tree Way for the purpose of acquiring personal belongings such as toiletries, clothing, items for work. All right, thank you.
You guys have a good day. Thank you, Your Honor.
Bye-bye. Okay, next this one's it.
Today as to this charge. If you've got any other holds or any other sentences that you're serving, you've got to resolve those before you're released. But as to this charge, if this is all that's holding you, you'll be released today. Mr. Masonette, you've entered a plea. I've accepted your plea and I've imposed a sentence. If you think my sentence is illegal, you can appeal me. If you want to appeal, your appeal must be in writing. filed within 30 days, and if you cannot afford an attorney for that appeal, I can appoint one. All right? All right, sir, good luck. Thank you. Next, I have Montez Taylor.
Sir.
Good afternoon, Mr. Taylor. Is Mr. Taylor represented by the Office of the Public Defender currently?
No. No.
Nope. All right. All right, Mr. Taylor is charged with operating a motor vehicle without a valid driver's license. He's apparently not in jail on this case. Mr. Taylor, would you like me to consider appointing the public defender to represent you?
Yes, sir.
All right. Do I have an affidavit filled out by him?
He's gonna take the plea, Your Honor.
Okay.
We'd ask that you not appoint. He's just gonna incur extra fees.
You're gonna save him the $50?
Yes, Your Honor.
Okay.
Yeah, you don't.
All right, and Madam Clerk,
in the plea.
he has no time in, is that correct?
Correct, Your Honor.
That's what it says on here, I just wanted to confirm. All right, so Mr. Taylor, you tell me that you want to resolve this case by entering a plea of no contest to the charge of operating a motor vehicle without a valid driver's license. Is that what you want to do?
Yes, sir.
I've been handed a plea form. It's written in English. It has your signature on it. Do you understand the rights that you're giving up by entering this plea? They're all listed on this plea form.
All the rights to go to trial. Everything we went over.
Oh, yes, sir.
Okay. Has anyone pressured you or forced you against your will to enter this plea?
No, sir.
Are you under the influence of alcohol or drugs today?
No, sir.
You understand that if you're not a U.S. citizen, you could be deported?
Yes, sir.
And then lastly, since I'm going to be adjudicating you guilty, you understand that can carry forward if you're similarly charged. They can use this prior conviction to enhance a sentence down the road. Do you understand that? You know what I mean by that? You want me to take another run at it?
Yes, sir.
All right. Because you're entering a plea to this and I'm adjudicating you guilty, should you be released and go out and get caught driving without a valid driver's license
Oh, yes.
again?
Yes, sir.
They could say, wow, Mr. Taylor had a conviction on the 15th day of April, and they could use that to create greater sentencing opportunities for the state going in the future, which could include some mandatory jail time. You understand that?
What about the case that I have that I'm in jail for? Would it mess with that?
I don't know what you're in jail for. I'm not addressing that today. I'm just addressing the no valid driver's license.
Yes, sir.
All right?
I understand.
Do you understand?
Yes, sir.
Okay. All right, sir. All right, Mr. Taylor, I'm going to accept your plea of no contest to the charge of operating a motor vehicle without a valid driver's license. I'm going to adjudicate you to be guilty of that offense. There are mandatory court costs that should run you $306. I'm going to give you up to a year to pay that off. You had the benefit of some consultation with the public defender's office, but I didn't appoint them to represent you. So you got the benefit of that without there being a fee imposed.
Yes, sir.
Okay? All right. All right. Sir, you've entered a plea. I've accepted your plea. I've imposed a sentence. If you think my sentence is illegal, you can appeal me. If you want to appeal, that appeal must be in writing, filed within 30 days, and I can appoint a lawyer for that appeal if you cannot afford one. All right?
Yes, sir.
All right, sir. Good luck.
So you want to just to confirm, it's 0 days for the credit time, sir?
I understand 0 days because he's not in custody. Okay. Apparently he gets 1 day. I was wondering about that because he is in jail, but he just wasn't arrested on it. All right. All right, next we have Levon Wallace, Nedrick Levon Wallace.
Sir, how you doing? Good afternoon.
Good, how are you, sir?
Good.
Mr. Wallace is represented by the Office of the Public Defender. He's in custody on a charge of petty theft, a second-degree misdemeanor, thank you. And I understand he has 37 days credit for time served.
Yes, Your Honor. The offer from the ASA assigned was in a withhold of adjudication, credit for the time he spent in jail. There's a cost of investigation of $89.18 to the Orlando Police Department. There's a no return to 2814 West Kennedy Boulevard, which I believe is the Walgreens. He would like to accept the state's offer and enter a plea of no contest.
All right.
Your Honor, just for clarification, the cost of investigation is to Eatonville PD.
Oh, sorry. I'm sorry.
All right. All right. So, Mr. Wallace, you understand, I'm sorry, your lawyer tells me you want to resolve this case today by entering a plea of no contest to the charge of petty theft, which is a second-degree misdemeanor. Is that what you want to do?
Yes.
Okay. I've been handed a plea form. It's written in English. It has your signature and also the signature of your lawyer. This lists all the rights that you're giving up by entering this plea. Did your lawyer have an opportunity to explain all that to you?
You gotta say it louder.
Was she able to answer all your questions?
Oh, yes, ma'am. Yes, sir.
All right. Has anyone pressured you or forced you against your will to enter this plea?
No,
Are you under the influence of alcohol or drugs today?
no,
You understand if you're not a U.S. citizen, entry of this plea could result in your being deported from the United States.
yes, sir.
All right, sir, I'm gonna accept your plea of no contest to the charge of petty theft, a second-degree misdemeanor. I'm gonna withhold conviction of guilt, so it will not appear on your record as a conviction. I'm gonna sentence you to the 37 days in jail you've already served. So I'm gonna credit you the time that you've already served. So as to this charge and this charge alone, you're gonna be released today. If you've got any other holds or any other sentences that you're serving, you're gonna have to resolve those before you get out. But if there are none of those, you'll be getting out today. I'm gonna impose court costs, which should run $273. Cost of investigation to the Eatonville Police Department in the amount of $89.18. So that's gonna be pretty close to $350. I'm gonna give you up to a year to pay all that off. I'm also gonna require that you not return to the Walgreens located at 2814 West Kennedy Boulevard. No good comes of you going back there, so don't go back there. Is there anything else, State, before I advise Mr. Wallace of his appellate rights?
No, Your Honor.
Defense?
No, Your Honor.
All right, Mr. Wallace, you've entered a plea, I've accepted your plea, and I've imposed a sentence. If you think my sentence is illegal, you can appeal me. If you want to appeal, that appeal must be in writing, filed within 30 days, and I can appoint a lawyer to represent you on that appeal if you cannot afford one, sir. I wish you good luck.
Yes, sir. Thank you very much.
Thank you. All right, next I have Paul Jason Fott. And it looks like Mr. Fott has several things. First off, he's got a new charge of open container. He's got a new charge of possession of less than 20 grams of cannabis. And apparently he has a warrant for an arrest warrant for criminal damage to property. Out of Walton County. All right, so let's do that in that reverse order. As it relates to the out-of-county warrant, since that's from a different county, and that's that's Walton County, Georgia. So that warrant is for no bond. I'm gonna stay the bond at none. Someone from extradition is gonna come talk to you if they haven't already, and they'll explain to you the options you have as far as waiving extradition or seeking a governor's warrant from the governor of Georgia, whose name just escapes me right now. So that will be a no bond. As to the new charges, possession of less than 20 grams of cannabis and possession of an open container, those are both contained in, one is 2025 MM 402666 AO, that's the cannabis. The other is 2025 MO 400958. That's the open container. The open container is a city case. I'm gonna find probable cause. I'm gonna reduce the bond from 500 to 250. And the possession of less than 20 grams of cannabis, I'm gonna reduce that from 500 to 250. And Mr. Fott, did you want me to appoint the public defender to represent you on those Orlando, Florida cases?
Yes, sir.
All right. It looks as though you qualify. I'm going to appoint the public defender on the two Florida cases. Obviously, I can't appoint public defender to represent you on the Georgia case, but that lawyer may be able to explain to you what goes on. And I think that should be it. Good luck, sir.
Yes, sir.
Thank you, sir.
Yana Johnson refused.
Waive, Your Honor.
All right, so Nikas Johnson is charged with trespass on school grounds. He has, his lawyer is waiving his appearance. I'm gonna appoint the public defender on this case. He's also got a, well, let's address this one for now. On the charge of trespass on school grounds, I'm gonna find probable cause based upon the charging affidavit. I'm gonna stay the bond at 500, appoint the office of the public defender, and require that the defendant not return to the location of this offense, which is 4949 Silver Star Road. He's to consume no alcohol or drugs without prescription and possess no weapons or firearms. Mr. Johnson was also currently just released on bond on March 9th on the charge of possession of meth. Looks like he was ROR'd on that.
Yes, Your Honor, we filed a 33-day motion. State has not filed on the charges. It's back from February 4th. We'd ask, given they're unrelated, that you take no action.
All right, state hasn't made a filing decision on that charge yet?
Not as yet, Your Honor.
All right. I'm going to take no action on the case on which Mr. Johnson was out on bond, out on his own release. And we'll just see what happens with that. And that will take care of those, and that was all done without his being present. All right.
Waive, Your Honor.
All right, Mr. Lawrence is charged with battery, criminal mischief, and resisting an officer without violence. I find probable cause. The public defender has waived Mr. Lawrence's appearance. I'm gonna find that he qualifies for the appointment of the public defender. Appoint the public defender to represent him. I'm gonna stay the bonds on count one, $1,000 for battery, $500 on count two for criminal mischief, and I'm gonna reduce the resisting an officer without violence to $500. So the total bonds will be $2,000. No alcohol, no drugs without prescription, no weapons or firearms. And this was on a street corner, so there's nothing for me to trespass him from, and I've already appointed a public defender. Next, I have Arian Cordell Lowe.
How you doing? Arian Lowe.
Well, Mr. Lowe, thank you for asking me. Mr. Lowe's charged with battery.
I was trying to see if I get an R&R release, no bond.
All right, well, I'm gonna, do you want me to appoint a lawyer to represent you, Mr. Lowe?
Can I talk to you about my statement?
She's asking if you want a lawyer. Yeah.
Yeah, I want to know. I want no bond R&R.
Okay. It looks like he's filled out an application. He qualifies for the appointment of the public defender. I've reviewed the charging affidavit. I'm gonna find probable cause. I'm not gonna release does Mr. Lowe qualify for PTR?
No, Your Honor.
All right, what I'm gonna do is I'm gonna reduce the bond to $500. I'm not gonna release him on ROR. I am gonna require that he, not drink, alcohol, not, possess drugs without a valid prescription, no weapons or firearms, and I'm gonna require that he not return to the location of this offense, which is 700 South Orange Blossom Trail, which I think is a 7-Eleven?
It's a racetrack, Your Honor.
Racetrack. I'm sorry, it's located at 700 South Orange Blossom Trail. I'm not sure if that's what I said. And that will take care of that. Good luck, Mr. Lowe.
Contact, Your Honor?
I'm sorry?
It's a battery, so no contact with the victim.
All right, yes, no contact with the victim, and the victim's name is contained in the charging affidavit. Looks like.
They still have to prove it.
Again, Your Honor, it's an Apopka case, so no name is listed.
Gotcha. No contact directly or indirectly with the victim. All right, next I have Glenn Montour.
Up to the mic.
Okay, Mr. Montour is charged with trespass in an occupied structure. Based on the charging affidavit, I'm gonna find probable cause. I'm gonna stay the bond at $500. I'm going to appoint the Office of the Public Defender to represent Mr. Montour. I'm required that he not return to the Lynx bus station located at 455 North Garland Avenue. He's to consume no alcohol, possess no drugs without prescription, and no weapons or firearms. All right, good luck, Mr. Montour.
Sergeant here. Yeah. Yeah, mine has to be there.
All right, next I have Adnan Murzjak.
Your Honor, we have just a moment.
Sure. Maybe it'll be a plea on Montour. Maybe. I don't know. They're chatting.
All right, I just wanted to make sure, because for some reason, I skipped over you. Your Honor, I'm sorry, I skipped over Mr. Glenn. I just realized, because I remembered the Garland Avenue. He has a offer to resolve the case. It's actually adjudication of guilt, credit for the time he spent in jail, and a no return to the bus station.
That's Mr. Montour.
Yes, Your Honor. He would prefer to accept the state's offer and enter a plea of no contest
Okie dokie.
to the charge.
I guess I could have asked you about that. I'm glad you caught it.
Yes. Mr. Moncler.
Do we know how many days Mr. Montour has in? 2 days.
Full name or just?
I guess you should swear these people. I didn't do that in the last couple pleas, but they can always appeal me if they're not under oath.
You gotta stand right here first, because he has to go over the plea. You're good. And you don't need this.
Thank you, sir. Madam Clerk, would you go ahead and swear Mr. Montour?
Please raise your right hand. Do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, Mr. Montour, your lawyer tells me that what you'd like to do is resolve this case today. You're charged with trespass in an occupied structure or conveyance. And your lawyer tells me you want to resolve this case by entering a plea of no contest. I'd sentence you to the 2 days in jail you've already served, impose some costs, and require you not return to the link station. Is that what you want to do? You want to resolve it today?
Yes.
All right, I've been handed this plea form. It's written in English. It has your signature. I also have the signature of your lawyer on it. It lists all the rights that you're giving up by entering this plea. Your lawyer's been able to answer all your questions about those rights, has she not?
Yes.
All right. Has anyone pressured you or forced you into entering this plea?
No.
Are you under the influence of alcohol or drugs today?
No.
You understand that if you're not a U.S. citizen, you could be deported by entering this plea?
Yes.
All right, sir, I'm going to accept your plea of no contest to the charge of trespass. I'm going to adjudicate you to be guilty of this offense. I'm going to credit you the 2 days you've already served. So as to this charge and this charge alone, you're going to be released today. If there's nothing else holding you, there's no other sentences, no other holds, you'll be released. I am going to impose mandatory court costs, which should run you about $273, $50 for the services of your lawyer, and I'll give you up to a year to pay those off. I'm also going to require that you not return to the link station where this occurred at 455 North Garland Avenue. They don't want you back there. No good comes of you going back there. And I'm going to give you up to a year to pay off all the costs. Mr. Montour, I've accepted your plea. I've imposed a sentence. If you think my sentence is illegal, you can appeal me. If you want to appeal, that appeal must be in writing, filed within 30 days. And if you cannot afford an attorney, I can appoint one. All right, sir, good luck.
Yes, thank you.
Sorry for that. Hope you didn't have to do 2 sets of paper. I'm going to guess this is Adnan Murzak?
Correct.
All right. All right, Mr. Murzak is charged with trespass on property other than a structure or a conveyance.
And he doesn't have an offer, Your Honor.
I'm sorry, I did not hear you, Ms. George.
There is no offer on
Okay.
this case.
All right. Okay. I'm gonna find, based on the charging affidavit, there's probable cause for the charge. I'm gonna stay the bond at $500. Mr. Murzak, did you want me to appoint the Office of the Public Defender? Do you want to represent yourself or hire your own lawyer?
I would like to represent myself, please.
Okay. All right, sir. Conditions of your release, Mr. Murzak, are that you not return to the University of Central Florida Student Union, which is located at 12715 Pegasus Drive. Are you a student at UCF?
No, sir.
Okay. So there's no need for you to go to UCF at all, but you're definitely going to stay out of the student union. No alcohol, no drugs, no weapons, no firearms, and you're going to represent yourself. Good luck. Next, we have Xavier Rivera Rodriguez.
He was a mental health, Your Honor.
Can we reset for tomorrow? There's a credit time serve offer, Your Honor.
Okay, we'll reset Mr. Rivera Rodriguez for tomorrow. Mental health. I actually heard that time. And I'll be here tomorrow, so I can just, can hardly wait. All right, is this Jonathan Rodriguez?
Yes, sir.
All right, Mr. Rodriguez is here. Looks like his new charge is petty theft with one prior conviction. From the TJ Maxx, based upon the probable cause of, based upon the charging affidavit, I find probable cause. I'm gonna stay the bond at $500. I'm gonna appoint the Office of the Public Defender to represent Mr. Rodriguez. I'm gonna require that, conditions of his release are that he's not to return to the TJ Maxx located at 6716 Grand National Drive. He was, apparently Mr. Rodriguez is out on bond for another petty theft, ROR, at which time he was ROR'd on the last day of March. He also has, on the 29th of March, he was ROR'd on charge of attempted robbery with a deadly weapon ×2. First one is 2025 MM 400-560, and then the felonies are 2025 CF 2333 AO. State on the felony, the 2333 AO 2025. Is there have charges been filed?
No, Your Honor.
Okay. And then on the petty theft, he was ROR'd, the 2025 MM 400-560 AO. Charges been filed on that yet?
No, Your Honor.
Okay. State, what's your position on the charges on which he's out on release, ROR?
Your Honor, understanding that formal charges have not been filed yet, they are theft offenses, and defendant is now accused of another theft offense. Based on that, I would ask that you revoke and hold him at no bond, but at the very least, revoke and double his out on bond, Your Honor.
Okay. All right. I've if I haven't mentioned, I've appointed the public defender on the new case. I did do that. What's your position on the revocation of the ROR on the other two cases?
Your Honor, one was back from February, and it has not been filed, the felony case. And the petty theft was back from January, and no information has been filed. We'd ask that you take no action. However, we understand that they're similar in nature, so if you are inclined to revoke, I would ask that you revoke and double, given no information has been filed.
Okay. Well, to double would be double ROR, because you've been ROR'd on those. I don't know if those are pursuant to 33-day notice motions.
Correct, Your Honor.
So what I'm going to do is this. I'm going to revoke his release on his own recognizance on the petty theft in 2025 MM 400-560 AO. I'm going to set bond on that case in the amount of $1,000. On the attempted robbery with a deadly weapon, ×2, that's a Division 17 case. No charges have yet been filed. He was ROR'd on that. I'm going to revoke his release on those two. I'm going to set bond on each of those charges in the amount of $1,000. So he's going to have $3,000, 1,000 on the petty theft, 1,000 each on the armed robbery, so that's 2,000 on that charge.
Mhm.
And then I'm staying the bond at 500 on the new petty theft. And I'm appointing the public defender on all the charges. Actually, he's already got the PD on the.
Yes, he does.
On the charges he's out on release.
About 400.
Okay.
What about bondsman?
All right, next I have Franklin Rule. Mr. Rule's before the court charged with trespassing from the Circle K on Aloma Avenue. I'm gonna find probable cause. I'm gonna appoint the office of the public defender. I'm gonna stay the bond at 500. I'm gonna require that Mr. Rule not return to the scene of 3100 Aloma Avenue, the Circle K. No alcohol, no drugs without prescription, no weapons or firearms. Has there been an offer extended to Mr. Rule?
Oh, he has open competency cases.
Gotcha. All right, good luck, Mr. Rule.
There you go, Ms. Rule. Just follow him that way.
Next, I have Jason Scott. Jason Scott is charged with trespass.
Yes, Your Honor, and there's actually an offer. Here you go.
Oh, thank you.
You're fine. You'll sign here. To resolve the case with an adjudication of guilt, credit for the time he spent in jail, and a no return to 1652 East Cimarron Boulevard in Apopka. He would like to accept the state's offer and enter a plea of no contest.
All right, Madam Clerk, would you go ahead and swear Mr. Rule?
Please
Mr.
raise your
Scott?
right hand.
Mr. Scott, I'm
Do
sorry.
you swear or affirm that the testimony about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, Mr. Scott, your lawyer tells me you want to resolve this case today. To get it resolved, I've been handed a plea form which is written in English. It contains your signature and also the signature of your lawyer. This lists all the rights that you're giving up by entering this plea. You've had a chance to talk to your lawyer about those rights, have you not?
Yes, sir.
Has she answered all your questions?
Absolutely.
All right. Has anyone pressured you or forced you against your will to enter this plea?
No, sir.
Are you under the influence of alcohol or drugs today?
No, sir.
You understand that if you're not a U.S. citizen, entry of this plea could result in you being deported from the United States?
Yes, I do.
All right, sir, I'm going to accept your plea of no contest to the charge of trespass. I'm going to adjudicate you to be guilty. I'm going to credit you the 2 days in the Orange County Jail you've already served. I'm going to require that you not return to the Circle
I believe it was a
Racetrack.
racetrack, sir. Yes, sir.
The racetrack located at 1652 East Cimarron Boulevard.
Yes, sir.
All right, no good comes of you going back there.
Yes, sir.
Court costs are mandatory and in the amount of $273 plus $50 for the services of your lawyer. I'll give you up to a year to pay that off. Mr. Scott, you've entered a plea. I've accepted your plea and I've imposed a sentence. If you think my sentence is illegal, you can appeal me. If you want to appeal, that appeal must be in writing, filed within 30 days, and if you cannot afford an attorney for that appeal, I can appoint one. All right?
All right, thank you, sir.
You're very welcome. Good luck to you, sir. Good afternoon. Is this Rhonda Vaught?
Yes, sir.
All right, Ms. Vaught. All right, Ms. Vaught's before the court on the charge of criminal mischief, over $200 and under $1,000. I believe that makes it a first-degree misdemeanor. What is located at 111 South Forest Avenue? Do we know?
Restrooms.
Okay, they're just public restrooms?
Yes, sir.
Okay. All right. All right, I'm going to find there's probable cause on this charge. I'm going to stay the bond at 500. I'm going to appoint the office of the public defender. Has there been an offer on this?
No, Your Honor.
Okay, all right. All right, Ms. Vaught, I'm staying the bond at $500. I'm going to require that you not return to those restrooms, okay? No alcohol, no drugs without prescriptions. And I've appointed the public defender's office to represent you, Ms. Vaught. Good luck.
Did you say do what?
I've appointed the public defender to represent
God
you.
bless you.
Okay? Thank you. You as well. All right, next I've got Amanda Taylor. All right, Ms. Taylor's on, before the court on a warrant for a failure to appear for arraignment last August. Bond has been set in the amount of $2,000. I'm not gonna change that bond. That'll be a $2,000 bond. And I don't know whether the public defender's previously been appointed, but I will appoint the public defender based upon the affidavit. All right, good luck, Ms. Taylor. You're welcome. Next, I've got Scott Douglas.
Yes, yes.
All right, Mr. Douglas is charged with having an open container of alcohol. This is a city case. There's probable cause.
And
I'm
the
gonna-
offer is an adjudication of guilt, 3 days in the Orange County Jail. He currently has credit for 2, Your Honor. He would like to accept the state's offer and enter a plea of no contest.
Okay. And that was communicated to you by the city attorney?
The state on behalf of the city.
There you go.
Thank you.
Look at everybody getting stuff done.
There you go.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, good afternoon, sir. Tell me your name, please.
Say your name?
Scott Barry Douglas.
All right, Mr. Douglas, your lawyer tells me you want to resolve this case today by entering a plea of no contest to the charge of having an open container of alcohol. Is that what you want to do, sir?
Yes, Your Honor.
All right, I've been handed a plea form. It's written in English. It has your signature and also the signature of your lawyer. This lists all the rights that you're giving up by entering this plea. Your lawyer's been able to answer all your questions about these rights. Is that correct?
Yes, sir.
Has anyone pressured you or forced you against your will to enter this plea?
No, Your Honor.
Are you under the influence of alcohol or drugs?
Oh, no.
All right, you understand that if you're not a U.S. citizen, you can be deported by entering this plea.
Yes, sir.
All right, sir, I'm going to accept your plea of no contest to the charge of having an open container of alcohol in public. I'm going to adjudicate you to be guilty of that offense. I'm going to sentence you to 3 days in the Orange County Jail. You've got credit for 2 days, so that means you'll be released tomorrow, unless there's anything else that's holding you. There's also mandatory court costs, which are $223, a $10 filing fee, and $50 for the services of your lawyer. I'm going to give you up to a year to pay all that off.
And Your Honor, it hasn't been filed on, so there's no $10 filing fee.
Oh, well, look at that.
Yes.
All right. Your lawyer just saved you $10, so you're only into her for $40 now.
Thank you. You're welcome.
All right. All right, Mr. Douglas, you've entered a plea. I've accepted your plea, and I've imposed a sentence. If you think my sentence is illegal, you can appeal me. If you want to do that, you need to file it in writing within 30 days, and I can appoint a lawyer if you cannot afford one. All right, good luck, sir.
Thank you.
Juan Gonzalez.
Yes, Honor.
You'll sign right there.
Ms. George, did you by chance get an offer on this?
Yes, Your Honor, the offer is an adjudication of guilt, 3 days in the Orange County Jail. He currently has credit for 2 in court costs. You would like to accept the city's offer?
Okay.
On behalf of the state? And enter a plea of no contest.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
All right, sir, tell me your name, please.
Juan Almanza Gonzalez.
All right, Mr. Gonzalez, your lawyer tells me that you want to resolve this case today by entering a plea of no contest to the charge of having an open container of alcohol in public. I've been handed a plea form. It's written in English. It has your signature and also the signature of your lawyer. It lists all the rights that you're giving up by entering this plea. Your lawyer's been able to answer all your questions about all those rights, has she not?
Yes.
All right, has anyone pressured you or forced you against your will to enter this plea?
No, Honor.
Are you under the influence of alcohol or drugs?
No.
You understand if you're not a U.S. citizen, you can be deported by entering this plea.
Yes, Honor.
All right, sir, I'm going to accept your plea of no contest to the possession of an alcoholic beverage in public. I'm going to adjudicate you guilty, sentence you to 3 days in the Orange County Jail. I'm going to credit you the 2 days that you've already served, so you'll have one more jail day in. You'll be released as to this charge and this charge alone tomorrow. There's also mandatory court costs of $223, no filing fees.
No, Your Honor.
No filing fee, and $50 for the services of your lawyer. I'll give you up to a year to pay that off. Mr. Gonzalez, You've entered a plea, I've accepted your plea, and I've imposed a sentence. If you think my sentence is illegal, you can appeal me. Any appeal must be in writing, filed within 30 days, and I can appoint a lawyer if you can't afford one. All right? All right, sir, good luck. Next, I have Alfreda LaCapra.
Yes, sir.
All right.
And, Your Honor, there is an offer to resolve her case as well with an adjudication of guilt, credit for the time she spent in jail and court costs. She would like to accept the state's offer and enter a plea of no contest on behalf of the city. Thank you.
Please raise your right hand. Do you swear or affirm that the testimony about to give should be the truth, the whole truth, and nothing but the truth? Yes, ma'am.
All right, good afternoon. Tell me your name, please.
Alfreda LaCapra.
All right, Ms. LaCapra, you're charged with having an open container of alcohol in public. Your lawyer tells me you want to resolve this case by entering a plea of no contest to this charge. Is that what you want to do?
Yes, sir.
All right, I've been handed a plea form which is written in English. It has your signature and also the signature of your lawyer. This form lists all the rights that you're giving up by entering this plea. Your lawyer's been able to answer all the questions you've got about all those rights. Is that correct?
Yes, sir.
Has anyone pressured you or forced you against your will to enter this plea?
No.
Are you under the influence of alcohol or drugs today?
No.
You understand that if you're not a U.S. citizen, you could be deported by entering this plea?
Correct.
All right. I'm going to accept your plea of no contest to the charge of open container. I'm going to adjudicate you to be guilty. I'm going to sentence you to the 2 days in the Orange County Jail you've already served. Court costs are $223. There's $50 for the services of your lawyer. Ms. LaCapra, I've accepted your plea. I've imposed a sentence. If you think my sentence is illegal, you can appeal me. If you want to appeal me, that appeal must be in writing, filed within 30 days, and I can appoint a lawyer for that appeal if you cannot afford one. All right, good luck.
Thank you.
All right, next I've got Carl Lovett.
Yes, ma'am.
And, Your Honor, there is an offer to resolve his case on behalf of the city with an adjudication of guilt, credit, time served, and court costs. He would like to accept the state's offer and enter a plea of no contest. In exchange, we'd ask that you take no action on the out on bond.
All right, he's out on bond currently for a DV case. This is a minor relative to that alleged offense that he's out on bond. This is relatively minor. I would accept the plea and take no action on the charge on which he's currently out on bond. It looks like the state hasn't yet filed the anything on the DV case. Is that correct?
Yes, Your Honor.
All right. All right. So, Mr. Lovett, has Mr. Lovett been sworn?
Raise your right hand, please. Do you swear or affirm that the testimony about to give should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, sir, tell me your name, please.
Carl Lewis Lovett.
All right, Mr. Lovett, your lawyer tells me you want to resolve this case today by entering a plea of no contest to the charge of open container. Is that what you want to do?
Yes, ma'am.
All right, I've been handed a plea form. It's written in English, contains your signature, contains the signature of your lawyer, and it lists all the rights that you're giving up by entering this plea. Your lawyer's been able to answer all your questions regarding all those rights. Is that correct?
Yes, sir.
Right.
Yes, ma'am.
All right, has anybody pressured or forced you into entering this plea?
Thank you.
No, ma'am.
Are you under the influence of alcohol or drugs?
No.
You understand that if you're not a U.S. citizen, you can be deported by entering this plea?
Yes.
All right, Mr. Levitt, I'm going to accept your plea of no contest to the charge of having an open container of alcohol in public. I'm going to adjudicate you to be guilty of that offense. I'm going to credit you the 2 days in the Orange County Jail that you've already served. There are court costs of $223 and $50 for the services of your lawyer. I'm going to give you up to a year to pay that off. Mr. Levitt, I'm not going to take any action on the charges on which you're out on bond. I'm going to make an observation for you that you want to try to stay out of trouble because another judge on another day may not do that. They may revoke your conditions of release on the other case, and you may sit in jail till that's resolved. And that could be a while because the state hasn't yet made a filing decision, okay? So just be careful out there.
Yes, ma'am. Thank
All
you.
right. Mr. Levitt, you've entered a plea. I've imposed a sentence. If you think my sentence is illegal, you can appeal me. If you want to appeal, your appeal must be in writing, filed within 30 days, and I can appoint a lawyer if you cannot afford one. Good luck to you, sir.
Thank you.
2 days.
You'll sign there if you want to.
All right, next we have Dennis Miller.
Say your name.
Yes, sir. Dennis Miller.
And there is an offer to resolve the case with an adjudication of guilt. 3 days in the Orange County Jail. He currently has credit for 2. He would like to accept the offer and enter a plea of no contest, Your Honor.
All right, would you go ahead and swear, Mr. Miller?
Raise your right hand, please. Do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, good afternoon, sir. Tell me your name, please.
Dennis Javon Miller.
All right, Mr. Miller, your lawyer tells me you want to resolve this case today by entering a plea of no contest to the charge of having an open container of alcohol in public. Is that what you want to do?
Yes, sir.
I've been handed a plea form. It's written in English. It has your signature. It also bears the signature of your lawyer. It lists all the rights that you're giving up by entering this plea. Your lawyer's answered all your questions about all those rights, has
Yes,
she
sir.
not?
Yes, sir.
Okay. Has anyone pressured you or forced you against your will to enter this plea?
No, sir.
Are you under the influence of alcohol or drugs today?
No, sir.
You understand if you're not a U.S. citizen, entry of this plea could result in you being deported from the United States.
Yes, sir.
All right, sir, I'm going to accept your plea of no contest. I'm going to adjudicate you to be guilty of this offense. I'm going to sentence you to 3 days in the Orange County Jail. I'm going to credit you 2 days, which means as to this charge and this charge alone, you're going to be released tomorrow. If you've got any other sentences that you're serving or any other holds, you have to get those resolved before you get out. I'm going to impose mandatory court costs, which are going to run $223, $50 for the services of your lawyer. I'm going to give you up to a year to pay all that off. Mr. Miller, I have accepted your plea. I've imposed a sentence. If you think my sentence is illegal, you can appeal me. If you want to appeal, your appeal must be in writing, filed within 30 days, and I can appoint a lawyer for that appeal if you cannot afford one.
Yes, sir.
All right, good luck, sir.
All right.
All right, next I have Renzo Ruiz Pasos.
Yes.
Mr. Ruiz Pasos, you're charged with possession of alcoholic beverages in public.
Yes, Your Honor. And there is an offer to resolve the case. It is a withhold of adjudication and credit for the time he spent in jail as well as court costs. He would like to accept the offer and enter a plea of no contest. I did check.
Thank you.
Yeah, I asked her already. He said that.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
All right, sir. I've been handed a plea form which is written in English and has your signature on it. It also has the signature of your lawyer. This lists all the rights that you're giving up by entering this plea today. Has your lawyer been able to answer all the questions you had about all the rights that are listed on the form?
Yes.
Has anyone pressured you or forced you into entering this plea? No. Are you under the influence of alcohol or drugs that may have impaired your ability to think clearly? No. You understand that if you're not a U.S. citizen, entry of this plea could result in your being deported from the United States? All right. All right, Mr. Ruiz Pazos, I'm going to accept your plea of no contest to the charge of having an open alcoholic beverage in public. I'm going to withhold conviction of guilt. I'm going to sentence you to 2 days in jail you've already served. Court costs are mandatory in the amount of $223, plus $50 for the services of your lawyer. I'm going to give you up to a year to pay that off. Sir, you've entered a plea. I've accepted your plea and imposed a sentence. If you think my sentence is illegal, you can appeal me. If you want to appeal, that appeal must be in writing, filed within 30 days. And if you cannot afford an attorney for that appeal, I can appoint one. All right, sir, good luck.
You'll sign here, Mr. Strickland. And I'll release you tomorrow.
All right, is this Emmanuel Strickland?
Say your name.
My name is Emmanuel Bartholomew Strickland, sir.
All right.
And there is an offer to resolve his case with an adjudication of guilt, 3 days in the Orange County Jail. He has credit for 2. In court costs, he would like to accept the offer and enter a plea of no contest. And in exchange for taking the offer, we'd ask that you take no action on his out on bond, Your Honor.
All right, the other one is a trespass.
Yes.
Do we know, State, that goes back to, it's either March 21st or March 2nd, I can't tell. Has there been any charges filed on 2025 MM 402003AO?
Yes, Your Honor, it was filed on the 10th.
I'm sorry, didn't I hear you?
Yes, Your Honor, it was filed on the 10th.
On the 10th, okay. Oh, that's why it has a return date of May 15th.
Mm-hmm.
Gotcha, okay. All right, in return for the plea of no contest to the charge of possession of an open container, I'm gonna take no action on 2025 MM 402003AO. Mr. Strickland, you're gonna wanna be careful you don't get in any trouble before you resolve that other case. Another judge might revoke your release on that. You've been released on your own recognizance. Be sure you keep in contact with your lawyer on that case.
Yes, sir. Much respect. Thank you for giving me the advice. You're very right.
All right, thank you, sir.
Have a good.
Right hand,
Go ahead and
please.
swear, Mr. Strickland.
Do you swear or affirm that the testimony about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, Mr. Strickland, your lawyer tells me you want to resolve this case today by entering a plea of no contest to the charge of having an open container in public. Is that what you want to do?
Yes, sir.
All right, sir. I've been handed a plea form. It's written in English. It has your signature. It also has the signature of your lawyer. This lists all the rights that you're giving up by entering this plea. Your lawyer's been able to answer all the questions you had about those rights, correct?
I understand. Yes, sir.
All right. Has anyone threatened you or forced you against your will to enter this plea?
No, sir.
Are you under the influence of alcohol or drugs today?
No, sir.
You understand that if you're not a U.S. citizen, entry of this plea could result in your being deported from the United States?
I do understand. Yes, sir.
All right, sir. I'm going to accept your plea of no contest. I'm going to adjudicate you guilty. I'm going to sentence you to 3 days in the Orange County Jail. I'm going to credit you to the 2 days you've already served, which means as to this charge and this charge alone, you're going to be released tomorrow.
Respect. Thank you.
You're very welcome. If there's nothing else holding you, you'll be released tomorrow as to this charge and this charge alone. Court costs are mandatory in the amount of $223. There's also $50 for the services of your lawyer. And I'm going to give you up to a year to pay all that off.
Thank
right,
you,
sir.
Your Honor.
You're welcome. All right, Mr. Strickland, you've entered a plea. I've accepted your plea, and I've imposed a sentence. If you think my sentence is illegal, you can appeal me. If you want to do that, it's got to be in writing within 30 days, and I can appoint a lawyer for that appeal if you can't afford one. All right, sir, good luck.
Enjoy your afternoon. Thank you.
Thank you. You as well, sir. All right, next I have Lucas Acosta Vega.
Yes, Your Honor.
All right, good afternoon, Mr. Acosta Vega. Mr. Acosta Vega, it looks like you failed to appear. And there was a warrant issued. It looks like it's on 3 cases. I think they may have all arisen at the same time. Failure to appear for a refusal to submit to a breath test, driving on a suspended license, and driving under the influence. So you turned yourself in, and there's bonds set on that in amount of $500 each. I'm going to stay those bonds. So the total to get back out is $1,500. Did you want me to appoint the public defender to represent you on those charges?
You're appointed, Your Honor.
You are, okay. Appointed before you failed to appear. All right. So those are, oh goodness, these are 2017 cases?
Yes, Your Honor.
Oh, okay. 2017 CT 4851, 52, and 53. Okay, good deal. All right, good luck, sir.
Thank you, Your Honor.
Johnny Graham, bonded.
Oh, I'm so disappointed. Woodrow St. Patrick Graham. Bonded. Okie dokie. Next I have Danielle Benjamin.
Yes, sir.
All right, so Mr. Benjamin is here on the charge of aggravated stalking with a credible threat. This is a warrant, and bond was attached in the amount of $2,500. So based upon that warrant, I'm going to stay the bond at $2,500. There's also to be no contact directly or indirectly with any victims, co-defendants, or witnesses. No return to the scene of the offense. No weapons or firearms. I'm also going to add no alcohol or drugs without prescription. It looks like Mr. Benjamin was out.
If you look at, when I review the warrant, Your Honor, it appears the new case occurred in 2023. So I do not believe he was out on bond at the time. It's a 2023 case.
Oh, gotcha.
These cases occurred after the fact, so he wasn't seen on this case yet. This case occurred prior to.
Okay. So the case that I just stayed the bond on the warrant, that was before he was out on bond in 2024 on the other aggravated stalking?
Correct, Your Honor.
So based upon that, you're asking me to take no action because
He wasn't out on bond.
wasn't out on bond on these?
Correct, Your Honor.
All right. It seems to be correct. State?
That is correct, Your Honor.
Okay. All right, I will take no action on the other cases. I will make an observation that Mr. Benjamin's not helping himself collecting like charges. But I don't know anything about them, so. And does he already have, I see here he doesn't qualify for the appointment of the public defender on this case. Is he represented by the public defender on the other cases, or does he have private counsel?
No, I believe he has us, Your Honor. Yep,
He has a
he has
public
us.
defender.
Okay.
Yeah, he has a public defender.
Okay, Mr. Benjamin, keep in contact with your lawyers.
Yes, sir.
I'm not, because apparently, according to that sticky note,
He doesn't qualify.
he doesn't currently qualify.
Christopher Bracken? Waive, Your Honor.
All right, so Mr. Bracken's not appearing, and his appearance is being waived. He's charged with grand theft, auto, dealing stolen property, and false verification of ownership. This is pursuant to a warrant that was signed by Judge Dubois. I'm going to stay the bonds in the amount of $3,500 on count 1, $1,500 on count 2, and $150 on count 3, so that according to Judge Dubois' math, totals $5,150. That looks to be right. And require no contact